Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razan Pereira. The Fugitive Economic Offenders Bill aimed at preventing culprits from evading the legal process and fleeing the country was last week passed by the Lok Sabha as the opposition questioned the government's sincerity in taking any action against them. The House later passed the legislation by a voice vote as Finance Minister Piyush Goyal said that the government had brought an ordinance before introducing the bill in Parliament which reflected its aggressiveness in acting against black money and such offenders. To opposition demand to bring the bill with retrospective effect to book offenders who have already fled, Goyal said it was not possible as the legislation was the government and the government knows how to bring the accused to book. During the almost 2-hour-long debate on the bill, the opposition questioned the government's sincerity in acting against economic offenders, saying many of them have fled the country during its rule, even as the BJP maintained that the banks were being helped to recover their money. The bill will now have to be passed by the Rajya Sabha. On this edition of The Big Picture, we will discuss the Fugitive Economic Offenders Bill of 2018. Joining me on the program today are Piyush Singh, Advocate to the Supreme Court, A.K. Bhattacharya, Editorial Director, Business Standard, Chakshu Roy, Head Legislative and Civic Engagement Initiatives, PRS, and Nitin Desai, former Chief Economic Advisor to the Government of India. Piyush, let me start the program with you, of course. Let's try and put into perspective and understand what the Fugitive Economic Offenders Bill of 2018 is.
If I have to say the salient features of the bill, I would say one, it defines the fugitive economic offender as anyone who has been committing or has been an arrest warrant being issued for the scheduled offences under this particular bill. Scheduled offences are all those offences of the IPC, FEMA and other legislation which are criminally prosecuted. And any one of that person against whom a warrant of arrest has been issued, he is either abroad and refuses to return or escape such prosecution. He has been defined as fugitive economic offender. That is one. What happens then is number two, special courts which are already there under Prevention of Money Laundering Act. They have been designated special court under this new bill. Third thing, the director under this new bill is going to make an application to the special court in case any of the fugitive economic offender is abroad for his declaration to be a fugitive economic offender. Now the special court will have a discretion in this case of declaring him to be a fugitive economic offender or not, but mandatorily the special court will have to follow a procedure of issuing a notice to the fugitive economic offender to come at a specified place and a specified time in the country in not later than, or I would say 6 weeks minimum time is given under the particular bill. What happens after that, in case the person doesn't come, he will be declared as a fugitive economic offender, and once that is done, the director under the act and the authorities under the particular act and the bill will have the powers to confiscate the property and to attach the property, and an administrator to that property will be attached. Another very important feature of the act is that civil suits, filing civil suits or defending civil suits have been barred under the act for the fugitive economic offender, which I would say is a very proactive step by the government. Though a discretion has been given to the court that the court may allow for the filing of such civil suits or not, but clear, I would say, a bar has been given a power for the courts to bar a particular fugitive economic offender to file cases in any court of law or to defend any civil suits, be it insolvency proceedings, be it DRT or Sarfazi proceedings in any court of law.
All right. Talking about the salient features, Chakshu Roy, as was pointed out by Piyush Singh, several of the features were pointed out by him, but when it was debated, when this bill was debated in the Lok Sabha, we saw several members of the opposition asking the bill to be sent to a parliamentary committee. What was the reason? What was their reason asking the government to take the bill to the standing committee?
Frank, if we step back, before the ordinance was promulgated, there was a bill that was introduced in Lok Sabha, and the bill was introduced during the budget session of Lok Sabha. And even when the bill was being introduced, some members pointed out that there were technical provisions in the bill. Piyush was mentioning a specific provision about bar on defending civil suits. So they said that, probably it's a good idea if a bill could be referred to a parliamentary standing committee. When the bill was being debated in the House now, which was, the ordinance, the bill to replace the ordinance, one of the things members said was that there were a number of technical provisions. There were provisions related to search and seizure. There were provisions related to defense of suits. There were provisions related to, what will constitute as an economic offender. And they felt that if it went to a parliamentary standing committee, there would be a little more scrutiny with respect to the bill. Now, if I could just, draw into the debate of what happened in the debate. members reflected on a number of technical issues within the bill. One was with respect to what happens to existing economic offenders who are currently no longer in the country. That was one. The other aspect of why the limit of 100 crores. As Piyush very rightly pointed out, that there are two conditions to be fulfilled. One, that the scheduled offence, which is specified in the law, should be, have a monetary value which is above 100 crores. And the second is that there's an outstanding warrant which is pending. So, some members pointed out, even if it is 1 rupee or 10 rupees, it should come within the definition of this law. And why this level of 100 crores? Because somebody said, oh, you know what, if you're a 99 crore offender, will you go away scot-free under this law? And only if it's 100 crore and above. So that was another part. The third part was some members commented on the fact that there is a presumption of guilt without going through a trial. So does that violate rights of citizens? And the final point was, what does it mean that if you're not able to defend a civil suit, does that have constitutional implications, and could that be challenged in court? So that was roughly the debate that happened in Lok Sabha over 2 hours, as you mentioned.
Indeed. Mr. Bhattacharya, as far as the bill itself is concerned, has it addressed all the issues related to fugitive economic offenders, or do you believe that some more could have been done as far as the bill is concerned?
No, I think the manner in which it has been framed, I would imagine that all the specific issues that did come up in the wake of Nirav Modi leaving the country, or Vijay Mallya not coming back. So this was the environment in which this bill is actually direct fallout of the Nirav Modi scam. So I think it broadly addresses those concerns. The only thing which my fear is that it doesn't address is how do you enforce liquidation or even attachment and confiscation of property in a foreign country unless you have an agreement with the contracting parties. Now there is a provision in the law that you need to have, you can go to the contracting party, which is the contracting state, and enforce that. But for that you need to have those sovereign to sovereign agreements. So there are many countries, my understanding, that we may not have those sovereign to sovereign understanding where we can enforce these. So within the country, yes, I think we have addressed all the concerns. Of course, the civil claims bit is going to be controversial. 100 crore and 99 crore, as Mr. Roy pointed out, will be a debatable issue. But I think enforcing it across the borders will be an issue that needs to be handled in the days to come.
As a former UN man, Mr. Desai, how do you address this problem that Mr. Bhattacharya has brought up? The issue of, overseas issues, really.
I doubt if you can address it in that framework. Look. Why do you have tax havens? How is it that so many of these tax havens actually happen to be, even today, British colonies? So let's be very realistic about the extent to which you will succeed in getting foreign governments to go along with you in implementing this in their jurisdictions. But I think basically let me focus a little bit more on the potential impact. I'm not a lawyer, so I cannot comment on but I'm quite, struck by the fact that here is a criminal prosecution which is not necessarily meeting the normal standards of criminal prosecution, which is innocent till proved guilty, search warrants required for searches, etc., and so on and so forth. But let me leave that to the lawyers. In terms of impact, what I would say is this: if I'm an outsider, consider the position of people who have invested in the companies of which these people are promoters. As I understand it, under the law, that company itself gets disbarred. If X is a fugitive economic offender and is a promoter of company Y, then that company Y is also disbarred from pursuing any civil claim. That's my reading of what the provision is. And I think this could have a serious implication on the stock market and the willingness of people to invest. I would certainly wish to know, and now in future, is the promoter there an NRI who can run away whenever the need arises? Are there probable issues? Remember, lately we've had a situation of auditors resigning, and that has already created a little stir because investors are worried that is there something going on in this company which we don't know about. So in that sense, I hope it leads down the line to greater transparency and higher standards of corporate governance. But I will expect an impact on companies where there are issues of this nature. One more point I want to ask, in fact, an opinion on, because I'm not entirely clear, is what happens to the money which is realized? As far as I see, the government gets it. But the people have been, it's not the government necessarily which has been defrauded. There are other people who have been defrauded. I understand that if you're a secured creditor, your claim still stands. But what if you're not a secured? What if you're a worker whose wages have not been paid? Do you have any rights to that money? And I would like to get a clarification on whether there is any provision in the Act which specifies how the proceeds should be used. And I didn't see anything obvious in the Act. All it says is government gets hold of it when it is realized. You see, it doesn't say what is going to happen with this money
once the government gets it.
What are they going to do with it? This is not, because they may not be the people who have been defrauded. The people who have been defrauded may be others.
Right.
And it's those people who should have a right.
Right. Let's see if anyone has an answer to that question. Piyush, is there an answer really to that question? How do you deal with the money that the government gets?
There are two questions. That most of these frauds, one is qua the people or qua the, I would say, the public debt, or I would say from the banks or the sovereign debts. I would say in respect of the Nirav Modi scam, which we were talking about, Mehul Choksi, most of these offences will happen against the public sector, or I would say private sector banks. At the end of the day, this is public money belonging to the banks, irrespective of how it was, I would say the banks were defrauded in this whole context. Most of these offences which are above 100 crores, I'm not saying all offences, but most of these offences to the tune, they definitely defraud the public also. And I would agree with the viewpoint of Mr. Desai. But in the law, for example, with respect to the property, there's a concept of eminent domain. So which says that even if somebody owns a particular property, immovable property, the state will have the end control of that property. The state has the right to acquire it, the state has the eventual control. Similar right is in such cases where there is a magnitude or an offense of such a huge magnitude, eventually the state or administrator appointed, like in this particular act or in this particular bill, there will be an administrator appointed who will have the right to seize over the property and to even sell it or dispose of the property. Then under the law of equitable mortgage, like very recently in one of the cases of a Bunty Bubbly scam happening in Delhi, the Delhi High Court has held that in such cases the public will have a trust over that money. So irrespective, income tax authorities have a statutory due and government has a prior right. But in that case, firstly, the people who have given a money on a particular and they have been defrauded, they will have a trust, and this money was in a kind of a trust with that particular person who defrauded them. So statutory due or a eminent domain or all those principles will not apply. So I think in such cases, though the bill clearly says the money will be in the control of the properties will be confiscated by the government, but there are enough provisions under the law, in respective laws, where the person can go and file a particular suit or a claim before a particular forum and get the decree executed qua the government and take back that money. So that is there. That is definitely there.
Okay, I think that's a satisfactory answer as far as the issue that was raised by Dr. Desai is concerned. Moving on now, Chakshu Roy, what benefit will this bill have going forward?
Frank, I think two things. One is the statement of objects and reasons states as to what is the need for the bill. And possibly the idea for the bill is that how do you ensure that people submit to the jurisdiction of the court system in the country. Now, under criminal law, we have, if somebody does not appear before the police or join into an investigation, there is a provision where you can attach their properties and compel their appearance. So this is probably a civil version of that, where you ensure that people come and appear before the courts. But there are a number of facets involved. When civil offences come into play, the question of money, as Mr. Desai pointed out, the question of equitable distribution, as Piyush pointed out, starts coming to play. See, if a particular corporate entity was declared bankrupt, or there was liquidation proceedings, then there is a law which says there's a waterfall of things of how people get their money. Now, in the absence of that, what would happen is, while the government is going to get its money, there will be other people. There will be operational creditors. There will be people whose salaries are stuck. In a 100 crore offense, the ripple effects of that 100 crore are even more. So when the rules and regulations come out, it will be interesting to see as to how those ripple effects are operationally managed by the government. That's one part of it. The other part of it is the gap between the letter of the law and the implementation of the law, and that's something we always talk about in our country, that the intention of the law might be great, but if its interpretation and implementation of the ground is not very efficient, then a good law might not translate very well into the ground. So to give you an example, we have a special court. Now, this special court will obviously require a lot of technical expertise for going, for prosecuting offenses which are in the realm of 100 crore and stuff. How can we strengthen these special courts? How can we man them with experts? How can we get them outside help in terms of consultants, or people who can support them in understanding the technicalities? Because if that's not going to be the case, what would happen is that the time-bound nature of how these trials are supposed to proceed may get impacted.
I think that's a very important point that you've raised. Mr. Bhattacharya, the implementation of the law is going to be key as well, because we've seen that our experience in the past with dealing with special courts hasn't been too great. Also, these courts have been overburdened with time. We've seen how many cases that we have pending in the courts as well. One proposal, or several people have been talking about increasing the retirement age of judges, probably bringing in retired judges as well, so that the cases can be dealt with easily. Should that be done?
Yeah, I think it's a very relevant point. The capacity of our legal system is something that needs to get better, and which is why my understanding is that this 100 crore cutoff was kept, because if you bring it down to even 50 crore, or even 1 crore, as is the demand by some members in parliament, my sense is the system will get clogged. I mean, there's an issue about time, there's an issue about domain knowledge and expertise. So both in terms of the physical capacity of the special courts, there will be a downside, and also the special courts, as Mr. Roy pointed out, that do we have the competent people, the number of competent people that are required to deal with the various cases. Remember, there are 55 different sections of offences that are covered under the schedule, in covering 15 laws.
Yeah.
You have got Indian Penal Code. There are about 28 or 22 provisions under that. You have got Customs Act. You have Central Goods Act. You have Insolvency and Bankruptcy Code is also coming under it. So there are about 15 different laws under which 55 sections of offences can be looked at by the special court. Now, naturally, this need is not only building physical capacity, but also building domain expertise. You already have seen the way the IBC is being implemented. The courts are just overburdened with the number of cases, and according to one estimate, if the current pace continues with 26 NCLT benches right now operational in the country, it will take at least another 4 to 5 years to clear the cases which are already pending. So therefore, there is no doubt that I think we need to build capacity, we need to build physical capacity, we need to build domain expertise, and which is why my sense is that the 100 crore cutoff was kept, which is probably is the right thing.
Right. Mr. Desai, should the bill have been made retrospective as was demanded by the opposition, or do you think that wouldn't have made a difference at all?
I think that would have got it into serious trouble in law, so I suspect. Look, let's let them implement it at least in a few cases. Let us see whether they actually can do this or not. Let me comment a little on the domain expertise issue. You see, increasingly what we are finding is that our law courts are having to make judgments for extremely complicated commercial issues, and even on economic issues, but I'll leave economic issues to one side, but extremely complicated commercial issues. Now, judges, by their background and training, are not people who are au fait necessarily with all the niceties of commercial behavior. And I think we need a process of involving experts, independent experts, in the advising the court. Now, how to do that within our judicial system? It's possible. It's possible for courts to appoint special investigation teams, etc., etc. So it's not entirely. The courts have been fairly innovative in that. But I think some serious thought has to be given. I will always give one example. In France, when they had this situation where a lot of cases coming up in the Supreme Court involve a strong economic element, they appointed an economist as a judge, Frederick Jenny. In our case, this is impossible. And not only is that is impossible in a law court, it is also impossible in a tribunal, where there is a basic law which says every tribunal will be headed by a retired judge or something. So I'd say that we have to seriously look at how to connect sophisticated commercial expertise better with the process that is going on. I would say that I'm not entirely convinced that relying on the right of a person to demand compensation is sufficient as far as the distribution of proceeds is concerned. I think the rules and regulations must be framed to create, particularly I'm more concerned about the smaller people. As you know, in one of the cases that we are probably thinking of at the back of our head, one of the biggest one of the large chunk of the money is actually owed to former workers who have not been paid their wages for long periods of time.
Right.
Now, it's very unrealistic to expect each individual worker to go and file a case to get their dues. I would prefer to see something in the rules and regulations which recognizes the rights of unsecured creditors like that. It may be a small supplier.
Right.
So I would say, I would urge that when the government frames rules and regulations, they address this issue of the disposal of proceeds a little more systematically.
Okay, time now to get closing comments from all my guests, starting first with Piyush Singh. Let's talk about the fugitive economic offender as well, and who will be termed or categorized as a fugitive economic offender.
Right. So any person who has scheduled offences, who has committed an offence as defined in the scheduled offence, which is 100 crore above, who refuses to come to the country or has fled abroad, will be defined as a fugitive offender. Secondly, we were talking about whether this retrospective effect of the Act under the Article 13 of the Constitution, that is debarred. For example, for any civil law, you can have retrospective effect, but for any criminal law, that is completely barred under the Article 13, so therefore it cannot be applied.
Talking about civil and criminal provisions, what are the civil and criminal provisions that we have right now that are in existence to deal with this issue?
I would say, if you ask me, Fugitive Economic Offender Act was also equally covered already under the existing system under CRPC. Section 82 and 83 of the CRPC already had proclaimed offender defined. They used to have a proclaimed offender notice being there, all the procedure for attachment of their property, a procedure for having a receiver in place. But what this act goes on to do is I would say, to issue a warrant in a different country where the other country is a contracting state. So I would say the prosecution system also, one prosecution system can have it to work in a retrospective way in case they want, not otherwise under the constitutional framework, because it says not only somebody who's fled once committing an offense, somebody who refuses to come. So in case, even if somebody who has committed this offense prior, the government can still issue a warrant of arrest, and in case he refuses to come, this act will apply.
Okay. Chakshu Roy, closing comment from you.
Frank, two things. One, a balance, when the bill gets debated in Rajya Sabha, a balance between what the bill is trying to do and the rights that can be protected. That's one. Second, how do we strengthen our court system to deal with this? Can we get more experts in? Can we get forensic accountants, legal experts, people who can advise on cross-border transactions? Mr. Bhattacharya was referring to, how do you deal with other countries? So probably people who are expert in those kind of negotiations. So while the bill is going to be important, the rules and regulations that the government frames will be equally important when it comes to this particular bill.
Talking about the Rajya Sabha, do you expect the bill to be passed in the Rajya Sabha?
Well, it is listed. It is listed on the Business Advisory Committee, and it was listed today. And hopefully, it should come up. We have a long session left till the 10th of August. So I hope to see that that either the bill gets passed or it gets referred to a Senate committee.
Mr. Bhattacharya.
On the Rajya Sabha, I don't think that any political party or its members will have the moral strength to oppose such a bill or stall the passing of the bill. So I don't think you need to worry
sending
about
it to a standing committee.
Probably it may send to a standing committee, but ordinance is already in force, so
yes.
that's not an issue. Quick, three things that the government must do. Let me repeat some of the points. One is in India, we have lovely laws, great laws, but we have poor rules. So I think in this case also we need to focus a lot on how the rules are made and framed in a manner that they reflect the true spirit of the law, number one. Number two, build capacity. You create the special court capacity. Remember, the special courts are coming under the PMLA, Prevention of Money Laundering Act. So therefore, you need to really spend a lot, because that is one court which is not really adequately taken care of. So therefore, you need to build capacity there. Three is reach out to different countries with whom we don't have as yet the arrangement to have enforcement of the provisions under the law. I understand from Mr. Roy that we only have such arrangements in only 39 countries. So therefore, we need to really expand that list to make sure that very few countries are left. As a matter of fact, only no country should be left out of the purview of the contracting laws under the Fugitive Economic Offenders Law.
Right. Dr. Desai.
I would say that I think all the good points, I would agree with the points that Shavin made. I would add just one more. Really strengthen the investigation machinery which will support the prosecution. We have a serious frauds office. I think we need to do far more work in strengthening that machinery on the investigation side, because that will support the system, the director who is going to be in charge of implementing this law.
All right, on that note then, we'll call it a wrap on this edition of The Big Picture. What's emerging out of this debate is that we need to build capacity as far as the courts are concerned. We also need to have good rules. I beg your pardon. We have beautiful laws, but at the end of the day, we need better rules to implement any of the laws that are passed. With that, it's a wrap. Thank you to all my guests for joining me on the program and putting things into perspective for us. See you again next time.